Welcome everyone. My name is Ross Clark, partner and head of the GP team at Hempsons, and deal obviously with a lot of PCNs. So we're going to split this in two. I'm going to look at PCN company, while limited company, some of the governance around that, the role of the CD, is there one in a PCN company, and subcontracting to the company and some of the associated issues on that. That include VAT, but it's at that point I'll hand over to Jenny, who'll cover cost sharing groups and a solution to the potential VAT liabilities and taxation of a limited company generally. So why a limited company? Now Jenny's going to go into this in a bit more detail, but the primary reason for having a company is the ring fencing of risk in a separate legal entity. This mainly for PCNs, it stems from the employment of staff, particularly the ARS staff. So there's multiple numbers of staff, and actually that becomes quite a large liability for having all of those staff employed by one of the PCN practices. PCNs are talked about as a legal entity, but they're not a legal entity. Therefore, they cannot employ staff. It's actually the individual practices, and actually even a legal, a GP practice isn't a legal entity. It's actually the partners personally that end up employing the staff. So that's the primary reason for having a separate corporate entity. Is the company is a separate legal entity. Therefore, it employs the staff. It is therefore liable for them. And it takes that risk out of the practices and puts it into the separate legal entity. But as I say, Jenny's going to talk a bit more about the why you use a limited company in her discussions. So if you're not familiar, sorry if you are, but just if you're not familiar with the company, I think it's quite useful to understand the sort of three roles and some of the constitutional documents in it. So there's three roles in a limited company: shareholders who own the company, the directors who manage it on behalf of the shareholders, and employees who work in it. Now, forget employees, not because they're not important, but they are just paid to do a role that's set down in a contract of employment, and that's what they do. The real dynamic in a company is between shareholders who own and the directors who manage. And particularly with GP sort of companies, either at a GP Fed or as we're talking about today, a PCN company, it's the practices who will be the shareholders, but they will probably each have a director on the board, and it usually works out quite nearly. You might have 5 practices, 5 shareholders, and then they each appoint a director, 5 directors on the board. So actually, it's a very close company in that sense. But you've got to remember the distinction between the two, and it's really most of the power is with the directors on a day-to-day basis. Shareholders actually have very little day-to-day rights in a company. I'll come back to them when we get down to the articles. So one of the fundamental principles there is because the shareholders own, they can appoint and remove directors, and that's enshrined in the Companies Act. Shareholders can appoint and remove directors by way of an ordinary resolution. That's anything over 50%. So the ultimate remedy for shareholders is if they don't like what the directors are doing, they can remove the directors and replace the board. That's probably not relevant in a PCN company, but it's important then to look when you get to the Articles of Association, which is the constitution of the company. Usually there's a general delegation to grant the directors power to run the company. They can make all the decisions, and as I say, you're left with a default position there. If the shareholders aren't happy with the decisions being made by the directors, they can remove them. However, what you can do is build into the articles shareholders reserve matters where the directors must come back to the board. Now, this is useful in a PCN company setting where you might have, as I've said, 5 practices, each appoint a director. So you've got a director on the board, but that director is only one of 5 and could be outvoted by the other directors. So therefore, you could have in your articles certain matters that needed to come back to get the consent of the shareholders. And that provides a level of balance and protection whereby the directors are allowed freedom to run the company, but subject to certain matters where the shareholders are comfortable, they know that they will have to come back to them for a decision. Now, we're talking about PCN company here, and you've got sort of 2 options. You either mirror, because of course what we've got at the PCN under the network agreement is a PCN board, and it's equivalent, it's similar to a company. You've got all of the member practices of the PCN, but you've got a network board that runs the decisions about the desk directions and services to be provided to employ, etc. So you've got that already made up, and your network agreement is effectively a constitution for telling that board what powers it has, what decisions it can make. So it's very, very similar. So you could either mirror that within the company and just think, well, okay, we've got the network board. Why don't all the members of the network board become the directors of the PCN company? And therefore, it just mirrors each other exactly. And you might then not be worried about shareholder reserve matters. You just allow the directors to do it because they're the directors who are on the network board. Alternatively, you have an independent standalone company where PCNs decide, no, we want the directors of the company to be people who aren't on the network board, because then there's true independence and they can make decisions. And as you'll see when I come to the next couple of slides, there are actually statutory duties on directors to act independently. So that's the main choice. Do you just basically mirror what we've got in the PCN and use it like that, or do you have a separate board, completely independent of the network board, and decide that they can have a bit of independence in running the company? So the governance with companies is actually pretty good. There's often an impression that sort of companies are probably loose, fast and free with what they do, but actually the Companies Act is pretty extensive and covers a lot. But in particular, there are statutory duties of directors. There's 7 of them, and I've set them out here, but I'll just summarise them. The first one is directors must act in accordance with the company's constitution and only exercise powers for the purposes for which they were conferred. So effectively, you've got to comply with the articles. The directors can't do anything that would be out with the articles. So go back to that example I gave of a shareholder reserve matter that says the directors can't do this without the consent of the shareholders. So if 1 or 2 directors went off to do something contrary to that, they could be personally liable to the shareholders for not complying with the company's constitution. 172 is the principal one. It's the directors must act to promote the success of the company for the benefit of the members as a whole. And in a way, what does that mean? Well, it means, well, you're not thinking about what would suit my practice best. You've got to, as a director, consider what is best for the members as a whole. Now, obviously, people have their own vested interest, and that's true of directors sitting at a board meeting, as it is with partners at a partners meeting or network board members at a network board meeting. Everybody has their own interests, and in a way, there are conflicts throughout this, but conflicts can be managed. But as you're sitting as a director, you need to be sort of cognizant of these duties and think, wait a minute, what I'm making a decision here, what's going to be best for the company, for the benefit of the members as a whole. So that's the sort of primary focus when you're thinking about decisions as a director. You must exercise independent judgment. So effectively, not be prejudiced by your own conflicts, although that's natural. Everyone thinks about what do I want, but actually you mustn't. You've got to be independent of others and come to your own decision on that. And that's quite important when you're appointing people to the board. They must exercise their own independent judgment. Now, they can come back and speak to their practice and say, well, what would you like? And yes, they would probably carry that through, but ultimately it's up to that individual to decide what is the right decision at this point in time. And if the directors are nervous about that, although, as I said, the articles can have matters where they must go back to the shareholders, the protection for the directors, if they're a bit worried about making a decision, is to actually go back to the shareholders and say to the shareholders, look, give us guidance. What do you think we should do? You'd frame it in the way of a resolution to authorize the directors to do this, enter into this contract, for example. And the shareholders might not pass that and reject the resolution. And what they're saying to you is, don't enter into that contract. Or they might pass the resolution and say, yes, do it. Now, once the directors had that sort of steer from the shareholders, then they're fine. They're not exercising their independent judgment. They're following the direction of the shareholders, and that's fine. Directors must exercise reasonable care, skill, and diligence. And there's a couple of tests to that. There's an objective one and a subjective one. So, for example, if you're looking at the finances and you are trained as a finance director, for example, or you're the finance partner of your practice, you'll be expected to have a slightly higher level of understanding and knowledge of financial matters than, say, somebody who's a clinician and knows HR matters very well. So there's a balance there, but you must use reasonable care, skill, and diligence. Avoid conflicts of interest with the company, not accept benefits from a third party, and declare interest. So all of that's wrapped up in conflicts. And although you should try and avoid conflicts, the articles provide a sort of usually provide a process by which you declare an interest. And once you've declared that interest, you may be entitled to carry on and continue in discussions, sit in a meeting and vote, or alternatively, it may be decided, no, if you've got a conflict, you sit out of the meeting, you don't vote, and the others can vote on the matter. So the statutory duties are quite important for those that are stepping into the role of director, but they're fairly straightforward and quite sensible in there. Now, the key in terms of governance is you've got lots of hats. You might be a partner of a practice, you might be on the network board, you might be a director of the company, you might even also be the CD, the clinical director. You've got to remember each say, what hat are you wearing? Am I sitting down around a table now as a director of the PCN company, or are we sitting here for the network board? And you need to do that carefully to make sure, because very often we've had cases where people just sit down at one meeting, decide all sorts of stuff. Some of it's to do with the company, some of it's to do with the network board, etc. You need to separate those out and make sure you're clear that you start a meeting as a network board and then say, right, okay, we're now going to move on to the company. Let's close that meeting. We're now switching into a meeting of the company, the PCN company, and therefore we need to be recognised we are directors now and we're making decisions for the benefit of the members as a whole, etc., etc. Conflicts need to be considered, but everybody involved has a conflict because you're a partner in a practice, you're a member of the PCN, you might be on the network board, and you might be a director of the company. It's how you deal with them, and the articles and the governance structure provides for that. Now, what's really important, I think, is decision making, and this is the heart of governance, is making decisions as a board, not as an individual, and having those minuted. That's the best protection you can have. Now, minutes, and we've seen all kinds. You've seen, a 2-hour discussion sort of recorded as 2 lines versus, a half-an-hour meeting that didn't really discuss very much of importance recorded like War and Peace. There's a happy medium. The key is you need to get down really key decisions in recording, and it needs to sort of record the any objections to it, the sort of arguments for and the arguments against. Then you move to a decision and record the decision. Now, directors can get things wrong. That's fine because you haven't got a crystal ball. You can't see into the future. The test is, at the time, did you use reasonable skill and diligence, and did you come to a decision that was right at the time on the basis of the information before you? Now, as I say, you can get it wrong, but at that time, you all thought you were making the right decision, and that's the key. If you act collectively, you've got different people with different outlooks and different values and opinions, but coming to a collective decision is the best defense you have of any criticism from, say, shareholders. So governance is important, but the sort of constitution, the articles in a PCN company covers all of that. But it's down to the board mainly in terms of the decision making and how they make decisions and how they record them. So what about the CD, the clinical director? Have they got a role in a PCN company at all? And many people think not. But when you have a look at the various bits that around a CD, so for example, the DES spec, so the clinical director provides leadership for the PCN strategic plans as a direct and integral component of the overall network contract DES. PCN's got to ensure its clinical director has overall responsibility for strategic and clinical leadership and the development of a PCN workforce strategy, and lead a role in developing conflicts of interest arrangements. So you'll see then, particularly about having overall responsibility for strategic and clinical leadership. Well, if the company is going to form part of that by subcontracting delivery of services to the company, or even if the PCN company is just there to employ ARS and other DES staff and then provide them to the practices so the practices can use them in the provision of or the performance of the DES services. You can see there how the role of the clinical director does apply, either with the development of the PCN workforce strategy or strategic and clinical leadership. The mandatory network agreement says the CD has responsibility for delivering the relevant role requirements. So it's clear from that the CD's role can, and if not will definitely, clearly cross over the activities of the PCN company with the PCN, regardless of whether the PCN company is just there to employ staff and provide them back to practices or has a subcontract. So I think some thought needs to be given to that, particularly the role of clinical director, and possibly building that into the articles, i.e. the constitution of the company, to possibly allow for that role of the clinical director within the articles. The clinical director may, for example, be a member of the board. So each practice may, as I say, just pick one of their partners to become a director, but you may also want the clinical director, even though they might be a partner, also in a separate capacity there in their, remember about what hat they're wearing. They're not there as a partner of their practice, they're there as clinical director. Now that can sometimes be a bit uncomfortable because you might have one practice having two people on the board, one as a partner representing the practice, the other being the clinical director. But again, it's back to that, what role are they in? And the clinical director has these duties and he or she needs to comply with them and has this overall responsibility. So I think it's something that needs to be thought about in terms of adding them to the board. Also, if there's a subcontract of services delivery to the company, then that can be included within the subcontract, so that the practice's subcontract delivery of the DES services says to the company, you get on and provide them, you employ the staff, you deliver the services. However, our clinical director needs some supervision and some information and can direct certain things and has oversight in certain matters. So you build that in there. One thing that's very often missing, we don't see many have this, is actually for the clinical director themselves. Have they got a contract or a letter of appointment that says, look, here's all your duties. You need some independence. So what power do you give to that person to make those decisions? And what protection do you give that person in terms of carrying out those duties? And that's something we don't often see, is a contract or a letter of appointment that this with the CD saying, yeah, you're appointed to do this. This is your role. Here's what you can do, and you know, also obviously remuneration as well. Are they getting paid for that role? Very often not, but you know, there's backfill time to the practice, etc. for time. So there certainly is scope for a role of the CD within the PCN company, and I think it needs to be thought about in there. So just concluding my bit, just looking at subcontracting and associated issues. Which is common, if some of the DES services are being, and there's two broad models, you either use a PCN company for the employment of staff simply because you're sheltering the risk of those staff into the company because it's the company that employs them and it's the company that's therefore liable for them. So it might be just to shelter the employees are then provided back to the practices to deliver the DES services. The alternative is DES services are delivered or subcontracted to the company, so the company's actually delivering those services. Now, one thing that's important to recognise is you must use the NHS template DES subcontract. There are other subcontracts that were put in place prior to that, but that's the document that needs to be used for pension and CNSGP access. It's got a mandatory front end which you can't change, but the schedules can be developed. So, for example, you could cover the role of the CD in the schedules. The schedules are there to be populated in the template. And as I've said, it's now mandatory that you have and can evidence the template DES subcontract to be able to continue to get pensions access in the PCN company, and for the clinical negligence scheme for GPs, to have them covered in the company, the PCN company, it needs to be under that template subcontract in place. Now, we come on to the sort of three main issues. Pensions we've covered there. You can get pensions access, but you need to be using that template subcontract. CQC is another issue. If the PCN company is existing simply to employ staff and provide them back to the practice, it's not providing registrable services, therefore it doesn't require a CQC registration. However, if the company is providing the services, i.e. there's a subcontract in place, then it definitely does need a CQC registration. And we did, only a few weeks ago, we came across a situation where a company had been set up, it was providing the services, but didn't have a CQC registration. And we don't know why. I think we thought the practices just thought, well, we've got CQC registrations, that must cover these staff employed over there when they're providing, but no, it was actually carrying out services. So that had to be, well, in the course of remedying that, there's nothing you can do. You could be liable there. So it's important to remember, is the company carrying on any registrable services? If it does, it's got to have a CQC registration before it does so. The issue there is not about getting the registration, it's the time taken to get new registrations in place. The third issue is VAT, and at that point, I'm going to hand over to Jenny at BHP. And I will just say, we work closely with BHP. There are not many firms of accountants across the country that have good GP experience, and actually it's rare, the ones that do, to find good VAT specialists in them. Now, I would just hasten to add, we don't have any sort of formal connection with BHP. We don't have referral arrangements or anything like that, but I have dealt with them with PCNs, and the VAT advice was brilliant. It was really good in terms of what Jenny's going to cover. So it's great to get a firm that you're in good hands with for all aspects of it. The GP team cover, and their VAT team. So it's really good. I just wanted to mention that because it's hard for us as lawyers. We deal with accountants, and it's difficult to find a firm that has that kind of fit. But I would recommend them. So on that point, I'll hand over to Jenny to carry on with the VAT and taxation aspects.
Thanks, Ross. I have to say, there's not many of us at BHP that find VAT exciting, but our VAT team certainly do. Yeah, they talk for hours, for hours about VAT. So, hello everyone. I'm Jenny Hurst at BHP, Chartered Accountant. So, as Ross says, we do deal with a lot of GP practices, 80 currently. GP federation, many GP federations, and also an increasing number of primary care networks. We're also founder members of ASMA, the Association of Independent Specialist Medical Accountants. So what I'm going to cover today is, first of all, why should you have a limited company PCN? And as Ross mentioned, one of the main reasons for that is VAT. So we will have a look at VAT cost sharing groups, which is a way round the VAT issues. We're then going to pick up on a few other little bits and pieces, and move on to limited company taxation. And then finally, we'll look at what are the downsides of having a limited company, because there always are some downsides somewhere along the way with whatever you decide to do. So why should you have a limited company PCN? And this is really to address the issues which weren't considered by the NHS when the DES first came out. Remember it well, 31st of January 2019, when it was announced, and it was tax return deadline, and we were all busy, and then we had this big document to read at the same time. So one of the main issues is there's no entity for a primary care network. And one of the issues that can create is additional costs on staff. So I will look at this in more detail, but essentially, if you're not careful, you could be looking at an extra 20% on top of your existing staff costs. There was also, or there has been certainly a perceived risk for the lead practice. So where PCNs have an arrangement where one practice is employing all the staff, and those staff are used across all the practices in the network, then those lead practices have felt a little bit vulnerable. What happens if the funding's pulled? Am I going to be left with all the potential redundancy costs? This should be covered off in the network agreement, but it's not changed the fact that some of those practices do feel vulnerable. One of the other issues is where staff are employed by different practices across the network, then we tend to end up with different employment terms amongst the different staff. And there seems a little bit of unfairness on that when actually some of these staff are employed across a number of practices. So we can find a way around that. Unlimited liability concerns, Ross has already mentioned really. And then finally, if you've got a limited company as a separate legal entity, you've also got the ability to take on additional contracts at PCN level. So just focusing on the VAT issue, the problem with this is if staff are employed by your practice, but they're used across the network, then the recharge of those staff costs to other practices is a taxable supply for VAT purposes. Now, this only becomes a problem when you reach a figure of 85,000, because that's the figure at which you have to register for VAT. But of course, some practices may already be registered for VAT. So often, well, in fact, always dispensing practices are registered for VAT. So if they're in this situation, then they would have to charge VAT anyway. So when we're thinking about that registration limit, we're not just thinking about the amount of recharge of staff. We also have to consider any other income that the practice may have that is potentially VATable. And the sort of thing that we're thinking about there is generally private income. An example of that might be occupational medicals. So the purpose of doing the occupational medicals is not healthcare, and therefore we don't get that healthcare exemption. So we would have to charge VAT on those if in total we reach this registration limit of £85,000. So that's over a rolling 12-month period. So possible solutions to this issue of VAT on staff costs is, first of all, we could employ our staff on joint contracts of employment. The issue with that is those staff would have no access to the NHS pension scheme, and therefore, in most cases, that's off the agenda straight away. The other option is for the employing practice to be delivering a healthcare service rather than supplying staff. This rarely is the case in practice, and in fact most practices would probably not want to be responsible for delivering the healthcare service in other practices. It would also need to be in writing, written into a contract. And in addition, any admin staff, they couldn't be covered by a healthcare exemption anyway if admin staff were provided to other practices. So the third solution is the cost sharing group. And to achieve this exemption, what we need to do is form a limited company. So separate legal entity, and that company would be owned by the partners of the PCN practices. So normally we'd have one shareholder from each practice that would hold shares on behalf of the other partners in their practice. And then what would happen is the limited company would employ all the PCN staff, and they would then recharge the various member practices for their share of the cost of those staff. And the important thing here is there can be no profit element. So if there's a recharge at more than cost, then we completely blow the VAT exemption here. So long as we tick the boxes, then our supply of staff to the member practices would be exempt from VAT, so no VAT charge. There are a few hoops to jump through, a few qualifying conditions. The first one is that the cost sharing group has to supply services to its members. We'd quite easily tick that box. The second one is we must be carrying on a relevant activity. So all our members, in other words, the GP practices, must be carrying on a relevant activity, and healthcare is classed as a relevant activity, so that's no problem. The next one is any services that the limited company cost sharing group supplies have to be directly necessary for use in their relevant activity, so their activity as a healthcare provider. So the things that we can provide are staff, as mentioned, but we can also provide an admin function. We can provide HR, payroll, accountancy, or legal services, or IT. And they would, as long as we tick in all the boxes, they would be exempt from VAT. With the top one there. The final thing is that the company would not be able to supply these services to a non-member practice and retain the VAT exemption, because that would be seen as distorting competition. So you can only supply these services to your member companies to retain the VAT exemption. So a few other things to think about. If you have a limited company, that limited company would need its own bank account in its own name. Often there are two bank accounts. We'd normally suggest two bank accounts, one for the limited company itself and the funds belonging to the limited company, and then a second one that's held in trust for the PCN members. So that makes sure if anything happens to the company, that separate PCN money is protected. It is possible for the PCN DES to be subcontracted to the limited company. The money would be paid straight into the limited company. And that would mean then that the profits or surpluses within the PCN DES would actually belong to the limited company. And the company would pay tax on those surpluses rather than the current position of the practices paying tax on those profits. Of course, it's also possible to subcontract other contracts that the practices may have as well into the limited company. So just thinking about the tax on the limited company. So I've just touched on the fact that without the company set up, individual practices and therefore the individual partners within those practices will pay tax each year on any surplus within the PCN. And it's often quite a controversial topic with partners, because they're really not keen on having to pay tax on money that they've not seen at all that's sitting within the PCN bank account. Where you have a situation where you're subcontracting the PCN work to the limited company, then the partners won't have to pay personal tax on any surplus, because it would be the company who pays the tax. The company pays tax at different rates to the partners. So if the surplus is under £50,000, then the tax would be at 19%. Over £250,000 of profit, you'd be at 25%, and anything in between would be at 26.5%. So these rates of tax are quite considerably lower than the rates of tax that partners would pay, which is normally 40% or possibly 45%. So in some circumstances, we might want to extract the profits from the limited company and pay profits to the partners. And this would normally be done by payment of dividends. And in that situation, the partners would then have additional tax to pay. So a 40% taxpayer would pay a dividend tax rate of 33.75% on any income they received via a dividend. And if actually all the surplus was withdrawn, then there would not be a tax saving using this method. So the real benefit, I think, for practices here is a cash flow benefit, where any surplus still sitting in the company is not going to affect the tax payments of the individual partners, which, as I say, it doesn't tend to be popular across GP partners. So anything left in the company, nothing further for them to pay. So what are the downsides of having a company? As I say, there's always some downsides. Because a company has limited liability, there are various hoops to jump through. There are additional running costs, certainly in terms of additional accountancy and possibly legal fees as well. There would be the cost of the setup of the limited company, and also the annual accounts of the company would need to be filed at Companies House each year, and they would be on public record for everybody to see, although they are in a limited form. So there's limited information with a small company that the public can see. And then there's also an annual confirmation statement to be submitted. We'd also need to register for corporation tax and complete a corporation tax return every year. And if any of these, the deadlines for submission aren't met, then there would be penalties to pay. If we transfer staff to the limited company, this would be done under 2P rules. And I mentioned earlier that one of the issues with different practices employing the staff would be the different terms and conditions for each member of staff. But under the 2P rules, any existing staff would have to retain their existing terms and conditions. So you could only make that change and ensure staff have consistent terms and conditions for new staff, and then with the older ones, just move it into line over time. And then finally, if we do subcontract the DES or any other contracts for that matter, we would have to register for CQC. So just in summary, most of the issues that PCNs face are caused by that lack of entity, and a limited company would resolve that issue. I know a lot of my GP practice clients do use existing federations for the employment of staff, and it might be that that is sufficient for you and gets around the issue of VAT quite nicely. But for anything involving companies, it's really important that you do take professional advice, and at BHP and also Hempsons, of course, are very well placed to help you with that.
Thanks, Jenny. Yeah, anybody have any questions? There's also the chat function. If you want to ask a question in the chat function, we can see there, but anybody just come off mute, please, and ask away.
So thank you for inviting me to this talk, and I have set up a limited company for my PCN, and so I've got some specific questions. I hope that's all right. One of the things you mentioned was having all the money going directly into the limited company account, and I did understand from that you can pay dividends to partners. If you've got the money going into a PCN account and then you're just transferring the salaries of your employed staff, can you then use the PCN Limited account to put profit in? So you would transfer it from your PCN account into the limited company account as a way of holding money. Clearly, you'd have to declare it and some tax would have to be paid on it. But if it's not going directly into that account, can you do what you said and do the capital gains tax rather than the... God, I'm so out of my comfort zone.
Do you mean, don't worry. I think what you mean is, can you use the limited company just for employing the staff? Is that what you mean? And get the cost sharing group exemption?
So we do that already, but you did add that extra bit, which was you can put the extra money. Some PCNs, you said, use only one account, and if they use one account, then they could use capital gains tax for any money left rather than dispersing it. And so my question is, I have two accounts, but could I put some of the leftover money in the limited company account and then just pay capital gains on that, or would I be seen as trying to hide money, and therefore it's just better if I disperse it at the end of the year?
I think within the limited company, can you put your PCN money into that? Are you in a position where you've not subcontracted the PCN DES into the company? Are you just using your company for the cost sharing group?
Just for the cost sharing.
Right.
Group.
Okay. So there's two options for your PCN money. You either keep it outside of the company.
Yeah.
And in that situation, it can either be in a bank account outside the company. Often it's with practices, but ideally it would be held in trust for the PCN with, and not just ideally, it should be held in trust. Or if you want to, you can have a bank account within the limited company. Again, it would need to be held in trust, so you can move it into there, but that doesn't affect who pays the tax. So it would still be your partners that would pay the tax. It would only be if the PCN DES was actually subcontracted to the company.
I get that. Yeah.
That the income then belongs to the company, therefore any profit stroke surplus belongs to the company, and then it would be the company that pays the tax at the lower rate, and the partners would avoid having to pay individual amounts of tax unless we pay dividends to them.
Thank you. Sorry for unpicking that. And then this is a question for Ross. So we had terrible trouble getting newly employed staff into the NHS pension. Anyone that was already in the pension could go into it. And so we had to fill in some form for this year, which gave people access to the pension for this year. And I just wondered if you knew what would happen next year for pensions.
Yeah, it's the big question, isn't it? Yes, there's open status where you've got a GP transfer, but then for other staff, it's got a closed application, a closed direction. Now, what nobody knows, because the NHS Pensions is saying that's only available until the end of March.
Yeah.
Nobody knows what's going to happen with the GMS contract and the negotiations for that. We've got an election coming up, and this is another element of that, which is what's going to happen. So we are in the dark. Now, they have given an indication that it will continue on a sort of ad hoc basis. So I've got no doubt that it will continue. They won't just turn off the tap. That would just be catastrophic. But we're waiting to see what happens. One possibility, given, well, it depends on a change in government, I suppose, but the Conservatives have sort of indicated that GMS might come to an end in the next 10 years. You then question what's going to happen to the DESs, because the DESs sit on the back of a GMS contract. Could they be taken off the back of the GMS contract and put into a central pot to the ICB to then filter down to practices? So it's awful. I can't give you an answer because we don't know, and it's a case of wait and see.
That's okay. I have two specific questions as well. So when you set up a company, you make shares based on the population of the practices.
It can be, yes.
And so if you have a merger of an additional practice into your PCN, do you throw all the shares up in the air and divide what you have based on the population, or do you create additional shares based on the additional practice?
Well, it depends how it's structured. If you've got a merger of two existing members, it usually doesn't make a difference, because you just add the patient list together and they've got a combined shareholding that should equate to the equivalent of the patient list. If you've got a new practice joining, then yes, you need to issue new shares to that practice. But what very often happens is that throws the others out of balance, because you effectively, if you're issuing shares on a list size basis, it's fair, but the others effectively dilute because somebody else is added on. So the proportions will be correct because it's all on a list size basis, but each practice will get less than they might have done beforehand because there's another practice in the PCN.
What we sometimes see these days is practices being set up with alphabet shares, and therefore that it's flexible. in how much is paid to each practice. So as the list sizes change, then then their share can change with that as well. It's a bit different when you've already got an existing company set up differently.
Hello, it's a question for you, Ross. I'm sorry you can't see me because my camera seems to have gone on the blink here.
All right.
It was just about the CQC registration. I just didn't fully understand what you were saying, I suppose, and so I'm sorry if I'm asking you to repeat yourself. So in my PCN, we have set up the limited company already. We are using it merely to manage our ARS staff. So we've got a separate bank account for the limited company, which the money goes into and then goes out to them from it. So my question is, I didn't really fully understand whether one needs to be CQC registered for that or not.
Well, if the company, it sounds like the company is just there to employ the staff, and the staff then are provided to the practices and work in the practices and follow the direction of the practices, because the practice is actually delivering the DES services, then the company is not providing registrable services. If, however, the company is responsible for delivering or providing some of the registrable services, then it needs a registration. So that is commonly linked to there being a subcontract, where you say that the practices or the PCN network boards say to the company, we want you to perform some of the DES services. Extended access is a very typical one. You perform extended access for us, please. And therefore, when that takes place, then the company is performing services. It's delivering and responsible for the delivery of the extended access services, which requires the registration. But from what you've said, it sounds like it's like a lot of the companies, they're there to warehouse, for want of a better word, the staff, and have them employed a bit like a locum agency, and then provide them to the practices to use on the delivery of the DES services.
Okay, so I think that's probably fine then. I just wonder about an example of our, I'm not sure whether it's probably fine, but our social prescriber, for instance, is basically based within the PCN and then goes out to the practices to do work with them, but also does sort of centralized things, you know, simple things like coffee mornings and other things that actually involve all the practices. So she's kind of working from the PCN to do that. Does that cause any issue, do you think, or not?
When you say she's working from the PCN, do you mean the PCN or the PCN company?
From the PCN, really. I mean, she's employed by the company, clearly.
Yeah. That's fine. She's if it's the PCN that are directing it, i.e. the practices, that's fine. It's only if the company is actually providing services and delivering services. It can seem a bit confusing, but it employs the staff, and those staff are doing the services, but it's actually who is legally responsible for the delivery of the services.
Okay.
If the company is taking a subcontract that says you, the company, will provide these services, it's clearly the company. In the case that you've described, it sounds like actually it's employing the staff, and therefore you have the VAT issue, because you're not providing, the company isn't providing the healthcare services to get the exemption. Therefore, it's the cost sharing group exemption that Jenny mentioned that gives you the VAT exemption, because it's actually the practices who are providing the services, not the company.
Okay, yes, well, we have a VAT cost sharing agreement in place, so I think that covers that. Yeah.
Good.
Okay, thank you. I think that answers my question. Thank you.
Jenny, there's one for you. I think we have 3 VAT registered practices, 1 non-VAT registered practice. They would like to know if becoming a limited company would allow bulk buying of items such as drugs without any VAT issues, or will this not solve the problem?
I think I might have to defer to our VAT people on that, to be honest.
Yeah,
happy to come back on that one.
Yeah, I think obviously, I don't know that, not dealing with the VAT issue, but actually the bulk buying of drugs, I don't know if it would matter if you had a company, as opposed to saying we are 4 connected practices working, buying, using the buying power as a combined collaborative. I don't think having a company would give you the bulk, would make any difference to bulk buying. That would be the number of practices and how much you're buying. Another question here, if the PCN DES has not been subcontracted to the company and the company only charges the cost of the ARS staff salaries back to the PCN, how will the company ever have enough funds to run itself, e.g. admin and management costs, training costs? As I understand it, Jenny, I'll come to you. As I understand it, the company can include its admin and management costs.
Yes, it can. That's
right.
Okay. Absolutely right. Yeah. Yes, because that's seen as a cost of employing those staff. Yeah, that's absolutely fine. Yeah.
Fine. Another one, can the company take on other business in order to get some income in? And again, Jenny, I think it can, as long as you need to, then if it's a cost sharing group exemption, you need to be careful about what is covered by the exemption and what's not.
That's right.
Yeah. So if the company's taking other business and earning an income on it, then that'll be taxable, obviously, as income. But yes, it can do that. You just need to be careful to make sure that you're, if and I'm not saying that VAT would be chargeable in that.
I suppose if the staff, but they could do other things alongside the cost sharing group and the PCN work. Basically, that's not a problem. It could be kept separately.
Yeah.
Hiya. I'm sorry if you've already covered this. It was about the CQC registration. So we're not a limited company, but we're in the very early stages of starting to become a limited company. In regards to the extended access or extended hours, so as a PCN, we decided to take that on and not subcontract it to anyone outside. But the PCN doesn't deliver it, just one practice did. So that practice is obviously CQC registered, but because we're delivering it, I don't know how that falls. Would we need to be CQC registered as a PCN because one of our practices took on the extended access, or are we covered because they already are?
When you say the PCN, do you mean the PCN as the collaboration of practices, or the PCN company?
Well, at the moment, we're not a company. We're
fine. No, right. So
we're
there's
becoming a company.
Yeah, right. So forget, you're not formed as a company yet. So currently, as a PCN, you're all jointly responsible for delivering the services, but quite commonly, one practice will deliver one aspect, or will have the people to deliver one aspect. That's fine because you're all covered by your existing registrations. Now, the only thing you might need to look at is the locations from which you provide the services. So if, for example, you had some staff and you were delivering, extended access services, but we're doing it at a hub and not at your own practice, you might need to update your registration. Say we're also now delivering some services from this location. And generally, you'd want to make sure most practices have the same registration, but there are some other elements of services. I think vasectomies and minor operations is a separate class. So if you start doing something that's not on your registration, you just need to add that on. So, but none of that is a problem. You just update your registrations. The problem comes is if you want a company to perform services, it's not the problem actually getting the registration. It's the time taken for CQC to be now processing applications. It's about 16 weeks. Approximately, it varies, but it's a timing issue that if you want the company to get up and running and start providing services, there might be a time impact on that. So again, thinking ahead to you're going to set up a company, do you want it to provide services directly? If the answer to that is yes, we do, then you think you do need to start the registration application soon. If you're thinking no, we just want the company to house the staff, you don't need to worry about CQC application, but you do need to start thinking about Jenny's point about cost sharing group and VAT, etc.
Okay, no, that's great. Thank you very much.
If we are a one practice PCN, is a cost sharing group still required to avoid VAT? No, it's not. If you just one practice, it's nice and easy. The staff that you employ are being used in your own practice only, and therefore you don't need to worry about the cost sharing exemption.
As a CQC registered limited company, I can highlight that there is not much guidance for these types of organisations versus other providers. This could become an issue as more PCNs move to these types of arrangements. Yes, that is a good point. So CQC have been talking about, generally the focus is on the provider. But with CQC companies and other companies like that, CQC have been looking at whether and they've looked at it in the context of large groups of practices, where you've got somebody that runs numerous practices, is actually an additional responsibility. Okay, you're not the direct provider of the services, but you're the manager and supervisor of all of the other practices. And I don't think anything's been done about that. But in terms about a supervisory role, that if you are a company that has several practices or several surgeries, yes, you need somebody on patch on that surgery that's actually responsible on a day-to-day basis, but you need to have somebody at the company responsible for sort of overall supervision of the clinical provision of services. And you're right, there's nothing around that that I'm aware of just now. And I suspect if more PCN companies, as PCN companies grow and CQC will be coming across more and more companies as providers, then they will, I think, amend the guidance and introduce requirements for supervision. Thank you. Can I just, on behalf of Jenny and myself, just thank you very much indeed for your attendance. I know time is really valuable, and I hope you found this useful and informative.
Thank you, everyone.